uh, I think I'd like to do is just have sort of an informal conversation amongst the three of us to talk about some of the bigger issues in the field and get your thoughts and opinions on those. And then I'm sure the audience will have lots of questions that we can debate as well. So, oh yeah, didn't I just do that? Oh, all right. Let me start again. For the TV audience, this is Stephen Middlebrook of Womblebond Dickinson and David Otto of Martin Davis PLLC. Yeah, and they're attorneys. They're both at this point have a fair amount of experience in the cryptocurrency and blockchain space, and so we were just going to have this informal conversation, these guys, about the law and cryptocurrency. So probably start out, seed the conversation for a half an hour or whatever, and then if you guys have questions, just raise your hand, as we kind of come to the end, and I'll make sure to check in so we can jump up and get the mic going.
Well, we were mentioning that. We're worth mentioning that Stephen represents PyroFX, and I represent Archain, and that's kind of what brings us together.
Thank you. That's definitely good. Okay, so it's tax week, right? Let's start with taxes. So, the big question at the Rock Rev Swap talk yesterday was related to, what constitutes a taxable event when you swap one cryptocurrency for another, right? So, David, do you have any thoughts on, what the rules are likely to be there?
Well, the IRS views crypto as inventory, right? And so the swapping event probably has something to do with your business model and how you're holding it. But if it's at an individual level, and you're looking to, I'm not exactly sure what the swap event is, but if it's if you contemplate the fair value exchange, there's probably no tax event at all on a one-for-one basis, like kind exchange. But I don't know if that's what's contemplated. What do you think, Stephen?
Well, I think for the Rock Rev Swap, the issue some people may have is that your basis in the Rock is going to be lower than the value of the Rev at the time, depending on how you determine that. And that's, an open question there. There are the exchanges with prices for Rock at the moment, but it's still fairly thinly traded. I think if most folks, if you dumped a large amount out there, that market would probably collapse. So I'm not sure that you could use those prices, or that you would be forced to use those prices as the fair market value. So I think you've got a couple issues there.
Oh, no.
But a lot of the people are not going to know what Rock Rev Swap is. So
okay. Well, they should watch the video from yesterday. The Rock is the token that Archain issued last year, and they did a number of private sales. The Rev will be the native staking token of the Archain blockchain once it launches. And so there will be a conversion event where we basically turn rocks into revs on a one-to-one basis at the network launch, right? So yesterday I gave a talk for about an hour, went over to all the details of exactly how we intend to do that, and took a number of questions. I thought the conversation was really good, so I do encourage people in all seriousness to go check it out.
That's a good point, Stephen. This whole issue of if you're looking at it from a basis standpoint, and given the relatively thin liquidity of presumably the Rev, that it wouldn't trade much differently than the rock, or at least it would trade much differently from establishing a valuation for purposes of having to be taxed on some spread between your basis and the value of that currency you receive, rev. You'd have a hard time. I think you'd have a hard time this early in the game. You'd be doing yourself a disservice if this early in the game you marked it to market.
Yeah, and I think at the discussion yesterday, there was a request and an idea that we should do some more research on this, which I think would be valuable. I spent some time last night thinking about whether there might be analogous situations from the past that we could market, that we could look to. One of which I was thinking of, particularly in the armed forces, they issue military scrip, and then frequently pull that and replace it with a different military scrip in order to prevent black marketeering and that kind of thing. You know that there's no you know that those were structured so there's no tax consequence to the military people who do that. But it'd be interesting to know how they got to that analysis. So it would be interesting to look at things like that, look at situations maybe in bankruptcy court or elsewhere where a company that existed in one form is being reconstituted in another form. Because in a sense, really, the rock's only purpose was to, at some point in the future, be redeemed for a rev. Yeah. Right? And so, at an intuitive level, that shouldn't be a taxable event. Now, getting tax law to mimic common sense may be a little difficult, but we give it the old college try.
Right on. Cool. Switching topics, I think one of the things that we've seen over the last quarter is a lot more activity from regulators that have an interest in this space. And there were a couple of interesting speeches that were given in articles that were written by leading regulators. In particular, I remember reading a speech by the chairman or commissioner of the CFTC, where he sort of laid out that there wasn't really any daylight between them and the SEC. You were going to be regulated by one or the other, but seemed like he was asserting fairly strongly that it had to be one of them. That has also come on the heels and commingled with a bunch of enforcement actions by the SEC against various different token issuers. So I think a lot of folks will be interested to hear your opinion as to where we're going, what your impressions of those kinds of statements are, and what in particular I think what application developers should be doing as they try to structure their business to make it most viable going forward.
Yeah, that's a big question. So the CFTC calls crypto commodity. The SEC more or less calls it a security. The IRS calls it inventory. FinCEN says if you sell it, you're a money transmitter, you need to be licensed. So make sense of all that. Yeah, that's kind of where we are right now. The regulatory landscape. So the SEC is trying to get their arms around this for all the obvious reasons. They think it looks and walks and quacks like a duck, so therefore it's a security. The CFTC in 2015 said crypto is a commodity. And I think it was February of 2018, the CFTC v. McDonald in Eastern District, New York, federal court reiterated that crypto is a commodity. So there's a lot of, you're probably seeing a lot of this as well, there's a lot of noise in the bar that says it's all a security, utility is dead, it's got to be Reg A plus or Reg D, it's a SAF that rolls into a security. Everything's a security. And if you treat it as a security, then you're safe, or you're safer than trying to articulate a rationale for it not being a security. I'm not sure I agree with that. And I don't agree with that on a couple of levels. First of all, the standard in this country, more or less, is the Howey test, investment contract. And so the Howey test, for those of you who haven't come across it, there's a analysis by Supreme Court that says for an investment contract to be considered a security, it must include 4 elements. There must be an investment in a common enterprise with the expectation of profits to be derived from the efforts of third parties. So that's the test, and it hasn't been overruled, and it hasn't been discarded. And if anything, the SEC has been looking to try to further enforce it. So that should be the framework. At least should be where we start in terms of looking at, all right, a company's looking to do a token sale, either private token sale or an ICO or something related to that. How is what you are doing structured in such a way that it either meets the 4-part test of Howey, and therefore it is a security, and therefore you don't have much of an opportunity to argue that you're going to do anything other than sell it under a Reg D or a Reg A+. But even if you do that, I'm not sure you want to go down that path. I suspect that if you come to the analysis that your token is a security, you'd probably want to look at just selling equity. There's another thing that's going on relative to this whole transition of tokens to securities, which is who's selling the security token. The crypto exchanges are not licensed broker-dealers. They cannot sell securities. They have to be licensed to do so. The securities dealers, the broker-dealers, are not selling cryptocurrency. So we're in this position where the bar is tending to kind of err toward safe, not the safe, the instrument, but the safe position, which I'm not even sure is that safe, which is it's all a security, or just treat it as a security. But I'm not sure that helps the companies that much. And the SEC's, if you sort of boil it down, it's really more, how did this happen is where the SEC is. They were behind the curve. This got ahead of them, and it took off, and it outpaced venture capital financing, and became a pretty robust market in a hurry, and relatively outside the sight of the SEC so the principles that they've worked with. There's a very strong argument that if you construct your token, and not artificially construct it, but construct it in a way that you're outside the Howey analysis, or you're not an investment contract, that you should be fine. So that's kind of the way I look at it. I'll give Stephen a shot at this and go from there.
Yeah, I mean, I think I agree with most of that. The chairman of the SEC has said most of the ICOs he's looked at were securities, but he's also said that there is at least theoretically this utility token, which is not a security. And I think that's probably right, but that utility token is probably not much more than a glorified gift card. It's something that you can use to, buy a T-shirt at the Gap, and not much more. And for, I think, most of the things people are wanting to do, especially in sort of the development phase where it is raising money to support development of services and products, that you're going to have a problem. Down the road, when you're up and running and you've got an existing product and you want a token to facilitate commerce in your system, then you may very well be able to issue something that is much more akin to a utility token and use it to facilitate commerce inside your ecosystem. The other thing where I think we're going to see activity in the near future is on the exchanges, and in particular, I know the regulators are very concerned about market manipulation. Both the CFTC and the SEC have spoken about that. Haven't done anything yet. Frequently, the regulators will kind of sit down and carve up the landscape and say, we're going to do this and we're going to do that. So I think some people were expecting the SEC to focus on issuers and the CFTC to focus on the markets. That hasn't happened yet. I noticed in the news that yesterday, Schneiderman, who's the Attorney General for the state of New York, has sent out inquiries and demands for information from a dozen or so people in the exchange market. That may ratchet the folks in Washington up a little bit because there's going to be a fight over who's going to, be the regulator that tames the evil cryptocurrency market. So, in that sense, sort of competition between regulators will speed things up, and maybe we'll get answers faster.
And then that's apparently there's also some federal legislation relative to money transmission, because the money transmitter license is at the state level, and the feds want to. I think it's a controlled currency. They want to have their hands in that. So there's some movement around trying to figure out how to oversee this from a federal standpoint as well, which is probably not great news from the standpoint of sensible regulation, but probably not bad if it's streamlined from the standpoint of being able to secure a license that's applicable in all 50 jurisdictions, because that's really what you have to do now if you want to do an exchange. You've got to go into every jurisdiction, every state, and get licensed. And it's not cheap, and it is not quick.
Well, I think if you had some sort of federal license, that generally would get you out of state out of the state money transmission regimes. You mentioned the OCC. So the OCC, that's the Comptroller of the Currency, that's the federal banking regulator, had proposed what they called a fintech charter. So rather than chartering a bank that did traditional banking, they were talking about the idea of chartering these fintech companies that would provide services akin to banking, taking deposits, making loans, but it would be something a little different than a bank. And it isn't clear that they actually have authority to do that, but they were just sort of talking about the idea. But when they mentioned it, the states became apoplectic. And so the Conference of State Bank Supervisors, which is an organization of all the state banking supervisors, and also the New York Department of Financial Services actually sued the OCC to try and prevent them from going forward with what was just an idea, not even a proposal. So given that reaction, I think a federal charter, if it ever happened, is years and years and years down the road. So that's not going to be a viable solution for like anybody in this room.
I agree with that.
Cool. I think one of the things that people have to confront when they're building companies, right, is sort of obviously what not to do, but from a developer's viewpoint, I want to see the how-tos, right? So I want to know what I can do, right? So I'd be interested to hear from each of you about like the one ICO or one company that you think has done it the best. Which one might you pick as an example? Not including
No.
So I mean, just if you were giving advice to a young developer out there and they wanted to go start doing research and look at how somebody put a deal together, which one would you point them to?
Yeah, I need some time.
Okay. Well, and so the so much about how you can, or what you can do, how you do what you want to do, how you map out how you're going to do that is a function of what it is you want to do. If you're building a next generation blockchain, you need to think of that ecosystem and what you're trying to accomplish in that business model differently than if you're running a bounty program, or if you're developing the sort of metadata token trading application for a commodities play. The business model will tell you a lot about the structure that's required. And the other thing I was going to mention on this whole state stuff is, remember, Massachusetts came out with a couple of weeks ago an enforcement action. All the states have their securities regulations that need to be complied with as well. So if you get comfortable with the idea that you're exempt from federal securities regulations because you're not a security for several reasons, you need to make sure that the states in which you sell your token don't have requirements in addition to the federal compliance requirements. And that's not always an easy exercise. For example, the Archain case, Washington State has an additional test. So they kind of go by Howey in the investment contract analysis. But they also have a test called risk capital. And the risk capital test essentially says that if you invest in something and you have no actual or practical control to vote and communicate with shareholders to kind of move the entity, you're more passive and more subject to the actions of a few, that you have no actual or practical control, and therefore your capital is at risk, and therefore what you've invested in is a security. And that's just one example of an additional test that goes on top of the Howey test. What were we talking about?
Recommend one.
Oh, yeah. Okay, yeah. So the model, what you are looking to do, how do you do that? But the legal pathway doesn't change. I mean, the law and the application of the law is relatively straightforward in the sense that if you look at Howey and you look at kind of promotion and marketing and advocating the value of the investment, those are things that you've got to be careful about. The SEC cease and desist with respect to Munchie, for example, which was a case where a company raised money around the issuance of a token that would promote restaurant reviews and attendance and the like. The SEC shut it down and said it was a security, and the company had a relatively simple and easy to understand utility. A token is being used to encourage reviews and is used to exchange goods or services at the restaurants. So that's kind of where the bar, at least is my read, Steve, that's where the bar is getting to the point where the utility token's dead.
Well, but in Munchie, I think the factor the SEC focused on was that they weren't selling the token to restaurants who would use it to incent reviews or reviewers. They were selling it to people who had nothing to do with the restaurant industry. And to the SEC, that meant this was clearly, some kind of an investment scheme. And so I think that's the crux that the SEC turned on in Munchie. Yeah,
that the solicitation to the sort of Bitcoin community as opposed to that more tighter ecosystem around restaurant reviews, restaurant consumption. So that would be an example of one that probably wasn't executed that well, but not because there wasn't utility. So think about the model and what you want to do with that model, and then don't do the things. This is really important advice. Don't do the things you shouldn't do.
Right, but to talk about Munchie, I don't know that much about them, so I don't know if they had other problems. But with a little bit of better legal advice, and I don't know if they had any at all, so that they had focused their token offering to people who actually would have used the token, that would have satisfied at least what was the primary complaint in the SEC thing. So yeah, they got slammed, but with a little bit of decent legal advice, they might have made it.
Yeah, and the other thing is, you're right, they got slammed because the bulk of the administrative proceedings, if you will, are subpoenas at this point. The cease and desist is a heavier hammer, and that's what they got. So that's that. A couple of the bounty deals. So some of what Martin Davis is doing now is we're in the business of writing opinions for companies that have issued tokens that want to list on an exchange, and the exchange is looking for an opinion to make sure that token is not a security. So that exercise is quite interesting, and not because it's that complicated. It's because you get into situations where you're looking at a deal, and to your point, Stephen, had they structured this thing differently from the start, it wouldn't be as hard to try to find a way to come with an opinion. It's also interesting how some of these companies are looking for the confirmation that they'll get the opinion they want before they hire. And of course, that can't happen. But it also isn't that hard to say, spend a certain amount of time on it, look at it relatively quickly, and give you a sense if you're going down the right track. But remember, these are all post fact.
So a company I think sort of did it right. I'm going to pick Ripple, only because Ripple, if you remember, and they've pivoted on their model a zillion times, but at least from a legal and a compliance standpoint, they had an enforcement action by FinCEN, I think in 2015, who said they were an unlicensed money transmitter. They needed to register as an MSB. They needed an AML program. They needed to file SARS. They needed to do all that kind of stuff. If I remember right, I think they fined them $700,000, which seemed like a big fine back then. It's getting dwarfed by things. But rather than just sort of folding up and quitting, Ripple sort of rose to the occasion. They hired more counsel. Hiring more lawyers is always a good thing.
I'm not so sure about that, because you get 5 lawyers in a room on an issue.
Right.
How many opinions are you going to get?
Yeah, and they built the compliance department, and they put all that stuff together. And they've sort of pivoted, I think, to a safer business model. I mean, they want to be the back end provider to banks now. So they're looking to take out SWIFT and ACH and the clearinghouse and those kinds of guys. And so that, for a number of reasons, is probably a smarter business model. Now, whether they still have some issues around XRP, I don't know. But the thing to take from Ripple, I think, is that even if you encounter some problems, some legal problems, they're not insurmountable, and they don't necessarily have to put an end to you or your company.
Cool. So, does anybody in the audience have any questions? Yeah. All right.
Guys, first off, thanks a lot. This is great input. So the question I have is about Munchie. So you're saying that with Munchies, the reason why it flagged the SEC was because they were selling to people that were not going to be using the service. But isn't this kind of the case for most utility tokens? And my understanding was that the main reason was because they were saying that they were going to give some kind of return, which then would fall into the Howey test of efforts of others.
Yeah, it was a combination. It was who they were soliciting, and then the promotion around what they were selling. And they did advertise it as an investment. Not a good idea if you want it to be treated as an asset. Not that assets can't be investments, but that's not something we're getting through to the SEC right now. Although there's case law that says it's pretty clearly. So it was a combination of the sort of investment return, the solicitation to the BTC community as opposed to a narrow subset, and the marketing of it. And there were some other examples around anticipated return. And that's really what killed it.
And I think if you look at the enforcement actions the SEC's taken, there's probably a lot of factors in each one, but I think they're trying to kind of focus on one or two in each so that they're all sort of a teachable moment. So like if you look at the actions against Arise Bank and then just most recently against Centra, in Arise Bank, they seemed very focused on the fact that you have bank in your name and you said you were a bank and then you said, well, we own a bank, or it's like, oh, well, we're going to buy a bank. And so the fact that there were fraudulent and misleading statements that made people think, and in particular, the fact that they were saying they were associated with an FDIC insured bank, which the regulators don't like because, that's sort of a holy grail kind of thing. And people think that their money and their investments are protected. So, they went after them in that. Sort of similarly in Centra, a bunch of issues, but in the complaint, they spend a lot of time talking about how they said they had a partnership with Visa, they had a partnership with MasterCard, they had a partnership with the Bancorp Bank, which is a big, one of the major banks that issues prepaid cards, all of which to sort of supported this idea that they were meshed into the traditional financial system and that you'd be able to access your money and all that kind of stuff. Again, I think in those things, the fact that they were trying to associate themselves with the traditional financial system, and even though there's like 100 other problems in the thing, and so in each of these, I think they take a teachable moment out, which is what we get instead of a reg saying you need to do this, this, and this. You have to read all of the enforcement actions and sort of glean the lessons to be learned from each of them.
Yeah, in that regard, that's a good point. If you take a look at the SEC report on the Dow, that was in large part not only sort of the investment nature of it, but the lack of ability to participate or govern what was going to be going on in the Dow. It was this whole curators concept. So people that came on board had no ability to influence or participate in how the Dow was going to evolve from the standpoint of funding the different projects. And that curators concept turned out to be fatal and certainly was a point of focus by the SEC. And so, as Stephen says, this whole idea that there's no bright line reg right now, and there probably won't be for a while. So you work through what's not working and what does work. The other thing that's interesting is Clayton, in one of his speeches a couple months ago, he referenced this concept of the Book of the Month Club, and that in the event that you are looking to establish a Book of the Month Club and use a token to find a better, faster way to distribute books or find buyers, you likely may not implicate securities laws. So the Book of the Month Club was a metaphor. It's not literally a Book of the Month Club. It's a metaphor where he's saying, hey, think about it this way. There conceivably is a way, at least in his remarks, conceivably is a way where you could construct an entity and create an ecosystem with a token that transacts in that ecosystem to do certain things, in that example, acquiring books and selling books, and likely not implicate federal securities laws. So the idea that utility is down, I don't agree with. I hear it a lot. I don't know if you do, Stephen, but...
Glorified gift card, like I said before. I think you can do it. It's just it's going to have such a restricted feature set that I don't think it's what most folks want.
Somebody else had a question, yeah.
What are your thoughts on the various mechanisms for selling a utility token to investors via a securities instrument, such as the SAFT, as well as there's some new mechanisms, for example, selling a equity alongside a token, selling equity that issues a dividend as a token, selling equity that has a warrant that gives the investor the option to receive a token, et cetera?
I think the sort of financing mechanisms to get this done become a little broader. The thing that I'm not quite clear on yet is if a token is a security and then that security, token security, gives you what? And then where does it sit on the balance sheet? And then what's the value that you, as the token holder, own relative to its, let's say, one example would be liquidity, at least near-term liquidity. So I'm not sure if I were going to do a token sale that was a security, that I wouldn't just figure out another way to do it. Equity, preferred, sort of standard stuff.
And I think if you think of the token as a bundle of rights, you need to define what those rights are to know how to treat it. So if you're going to issue equity and it's going to pay a dividend and a token, and that token is a glorified gift card, you're probably fine. If that token is actually, triggers all the points of the Howey test and is a security, then I'm not super up on this, but I think if you issue a new security as a dividend thing, you're still going to have a registration or an exemption from registration.
Yeah, it's going to have to be included in the original. So
again, it depends on what the feature set of the token is. And then it comes back to, like, if you're going to sell equity, why don't you just sell equity? I mean, at some point it's easier.
It's definitely easier. So it's really about what you're trying to get at. What are you trying to get at again? If you're trying to raise money and your token doesn't get you there from a compliance standpoint, in other words, you move into a security, then why sell a token as a security when you can sell equity or debt? Equity, common or preferred. And preferred still has some interesting stuff. There's a lot of interesting preferences and rights you can attach to that security. But the token, this whole business, at least my view, and the sort of emergence of the token and the ability to fund a business opportunity via the issuance of a token is a complete sea change from where we've been from an enforcement standpoint. And the bar seems to be trying to pull it back. And I can see why it would get pulled back if it doesn't have features and functionality that make it interesting and make it compliant and create a paradigm that works. But token for purposes of selling a token isn't interesting. But a token.
The other thing I was going to say is that I think you have to take a holistic approach to sort of the legal analysis of this. And so while you need to worry about your sort of SEC issues, you need to worry about your money transmission issues, you need to worry about your tax issues. And so, you can, if you sell equity, at least that money that comes in as a seller, is not a taxable event. If you're selling a token, you may very well have a taxable event. And so the money that's coming in is going to get reduced for that reason. If you've got tokens and you're selling them and it isn't clear, you may have money transmission issues at a federal and state level and that. So I think when you sort of think about, like, well, how do I deal with my SEC issues, and you start thinking about it, you got to think about all the regulators at once. You got to sort of juggle them together and take a holistic approach.
Did that get at your question? Okay.
Anybody else?
So I'm on staff for a organization that puts on conferences, and
want to introduce cryptocurrency to those patrons. And one of the ways that we were thinking about doing it is basically making up a coin that everybody that wants to participate will get a certain number of those tokens or coins, and would be able to freely distribute them to people that they like or meet, or maybe artists that they really appreciated. And then we were thinking about awarding more or less a prize to either top kind of coin holders at the end of the conference, or equally distribute based on the distribution at the end of the conference. Would that, if it's basically prize money, I guess, is there, what things do we need to worry about?
I would recommend you engage competent counsel.
Yeah. This is not legal advice.
Yeah, so my gut reaction is that you would be better off saying this is a game, and that you're playing a game, and it's like War of Warcraft or something like that, and this is an sort of game, and you need to make sure that there's not a mechanism for any of the tokens to be convertible to dollars. But then you're sort of building something that may not be, the example of what it is you're gathering people at your conference to talk about. So I don't know if that's, ultimately what you want to do or not.
Yeah, I mean, it's a part of it. Is there any value to it, or is it just like a gold star? The gold star program is clearly not a problem. But if you're looking to transact, to create some value out of that token distribution and allocation, we would have to understand that a lot better. Because that's where the rubber meets the road. When people think they're getting something by way of the token, and in getting that for services or for money, that they are enabled to do something with it. Exchange it for cash, buy another token, go to a restaurant, whatever the model is. So that would have to be fleshed out a bit more. But the idea in general of tokenizing some sort of performance event, and then it sounds like there's potential, but you just got to be careful about how that gets constructed.
And pick the state where your conference is held carefully.
That answer your question?
Yeah.
Okay. Yeah, exactly. All right, you got a couple more?
So what do you view as maybe some of the upsides of seeking like a Reg A Plus exemption, even if you're unsure whether or not a token is a pure utility token, but doing a Reg A Plus issuance of tokens or seeking that exemption? What are your thoughts on that versus, just taking the utility token fly?
Well, it's legal. I think that's I mean, it's fleshed out. You know what to do, and in a sense, it's a safe harbor.
Yeah, it's a security. It's a registered security. It's a short form IPO essentially. So yeah, it's legal. It's over tackle. It's pretty straightforward. No magic. You're registering a security, much like you'd registering a token, much like you'd register a equity or debt. Yeah. So that's there, and that registration process, whether it's an S1 or an SB2 or whatever it's been around for a while. So that's pretty straightforward. I don't view this business as being designed for that. That's there. I think the more interesting piece is this ability to look at how you create and build this new asset class, the token asset class, not in a way that violates anything, but in a way that's creative and value add, that's accretive, because it is a new asset class, and it's not a call on income, it's not a call on equity. It's got its own features and functionality. That's a big idea in capital markets. That's a big idea for building businesses. It's a big idea for early stage businesses accessing capital. But you have to be careful, increasingly.
So in sort of previous business endeavors, I've talked to a ton of different kinds of service providers, a handful of AmLaw 100 firms and accounting firms, all who have had like really good reputations and lists of clients. And, you know, you guys alluded to it. I've gotten a ton of mixed advice and some of what I consider is like pretty bad advice across like a variety of different subjects like token structuring, regulatory strategies, corporate structuring. So I'm wondering if you guys have principles or like smell tests that like we as entrepreneurs can apply when we're looking to like hire outside counsel. And then also like when we look to figure out how to assess that advice ourselves.
Yeah, Megan, I would just say, first of all, what seems to have been lost at some level in this tokenized crypto market is a financial model. And that doesn't go away because it's crypto or it's tokenized. And so from a entrepreneur standpoint, if you go in to talk to a lawyer, they don't at least start asking about the financial model. Because you essentially have two pieces of that. You have the narrative, what are you doing? And then the financial, how does the narrative dovetail with the financial? What does this mean from a financial standpoint? Your narrative. And if they're not asking you sort of the foundational questions around that, but they're into this tokenization concept, they're probably missing the point. I also think that if you don't have a token strategy, it's not really time to go talk to a lawyer about getting one, because the strategy should not be driven by the lawyer. The strategy should fit the business model. And then the strategy may need to be refined from a legal standpoint because it's got some issues that the business side didn't evaluate or know about for any number of reasons, and not up on the laws as much as their outside counsel would be. But I'd say sort of the foundational principles around what you'd be doing as a business are first and foremost. And anyone trying to squeeze the token, the token application, tokenomics, don't need to worry about how the business sustains itself. That's all bullshit. That's just not true. Because neither equity nor tokens are going to be around on a business model that craters. So those models will still be welcomed by the inevitable response. It's typically a lawsuit. I lost all my money. You didn't tell me this. You got advice misdirected. But if the question is how do you get good legal advice, perhaps it's by kissing a lot of frogs.
So I spent 10 years in-house, so the GC at two fintech companies. So, finding the right lawyer is sometimes difficult. I think you have to go on to the degree you can on personal reputation. So ask around in your industry who's using who, and are they any good? And besides, are they any good? Are they responsive? Do they listen? That kind of stuff. Typically the most expensive guy and probably the cheapest guy, are not necessarily the best options, or the cheapest or most expensive. I'm trying to think. So, I guess the last thing is we have to sit down and figure out if you can, if you can have a relationship with them, if you can work with them, if they're listening to you, and whether they're willing to sort of learn about you and your business. And especially in this space, I think there have been a couple of firms that built a cookie cutter solution, which they sold to a lot of people. And those people, I think, now have something that was made with a cookie cutter. And so, maybe your issues are just like everybody else's, but they're probably not. Is the council listening to you? Do they understand your model? Do they understand how it's different? Are they responsive to your unique needs? Those are the kinds of things I'd look for.
Yeah, and a little bit of experience. If they have some level of experience with what you are looking to have them do, so that looking at them is just as important. Interviewing them, how much of what you're looking to do have they done, is worth looking into as well.
Yeah. How many of their clients have gone to jail?
I think we have time for one more question, Zane.
On a private token that we would have before we would take it public, any advice on valuation of those tokens? What type of valuation we would put on those?
So that's a very interesting question. I mean, you're kind of making it up. I think the two things to think about, instead of answering the question, I'll sidestep a little bit. I think the two things to think about are both what are the tax consequences of the valuation you put on it, and what are the generally accepted accounting practices, and how are they going to look at that? And probably a private token without a market that's only redeemable for something in the future, I think from GAAP perspectives, is not going to be valued very highly. So, you can hold that asset on your books, but it's not going to be worth a lot of money. And sort of given that, I know some people want to put a big valuation on it, so they have a big number to talk about. I'm not sure that's always long-term in your best interest. But sort of think about that, and then, what the tax consequences are going to be, depending on what the plan for the token is.
Now, are you saying a private token in terms of a token that will just be held privately by a handful of people, or a private token sale? So it sounds like more of a private token sale than to be sold to a handful of people. And are you talking about the token sale, the value that you would put on that token? Okay. So 50 cents, $50, right? Yeah. Okay. That is a much bigger question. That is the question in this space, more or less. That and whether or not it's a security. And the valuation exercise is kind of all over the map. And I was reading an article on this issue a week ago, and there was a lot of talk about the market and how that all works out. And then there was a small paragraph at the end that says, so about valuation. Value the token as if this were the early stages of a like business that sells securities. That's not decentralized. So if you had the answer to the centralized Uber, you would value their proposition was you'd value your business early stage as decentralized Uber, as if you were an early stage Uber. I think that's a little crazy, but that was their notion. I think I don't think the valuation exercise relative to the business model changes at all. I think the valuation challenge is saying what part of that, what part of the business that generates value comes from the token and the token allocation and the movement of the token in the ecosystem. And that's not always easy to identify. It's not always easy to quantify. But that's really the challenge. And then your situation in particular, you really have to look at what you're doing. A lawyer would have to look at what you're doing to be able to give you any advice on value.
Okay, I think we've got about 5 minutes left. So, any final words of advice for devs out there? If there's one thing you could get them to.
Sure. I know everybody wants an answer to the legal questions and a list of these are the 6 things that we can do and not do. So that ain't going to happen. I think people need to recognize that you're going to get regulated. I can't tell you exactly how, maybe at this stage, but you're going to be regulated, and especially I think things like money laundering and terrorist financing are always going to be concerns here. And so you should think now about how you build your compliance programs for that. And I think you should also recognize that building those compliance programs are going to be problems that everybody else has. And so solving problems that other people have and that they're willing to pay money to have solved for them is frequently a good business model. So it may not be as sexy as some things, but sort of compliance and what in financial services now they call reg tech are business areas that I would recommend people look at, because the problems you're having, the big banks are having, the fintechs are having, the marketplace lenders are having, right? So, if you can, crack customer identification and verification and that kind of stuff and track it in a sensible way and do it in a cost-effective manner, you're golden.
Yeah, I think I guess I would go back to something we touched on a little earlier, and that's if this space is new and it's evolving and it has risk, and you have to decide, number one, are you prepared for that? And if you're not, stick with it as a security, because it's hard enough to be in the early stage developing a business, hitting the street for capital, convincing people your model makes sense, all the usual stuff that goes along with capitalizing and building a business. Now you're going to add to that regulatory uncertainty, legal uncertainty, conflicting advice, potential cease and desist or subpoenas. It's not worth it. It's not worth it unless you want to be in a space that has the power to decentralize, democratize, disrupt how things are being done. And if you want to do that, then you have to look at risk reward. And if you think it makes sense, then go for it. Then you need to start thinking about, all right, how do I do this? How do we do this structurally? How do we do it so it's compliant? Because there are ways to do it. But you have to want to be in that business. And that's a different business than just building a business. Not building a business is tough. Than building a business, issuing securities, going a traditional Series A, Series B, Series C, acquisition or IPO. That's a model that's developed. It's a centralized, traditional, fairly clearly regulated structure. That's been done. It's happening. It's available. It's been available. The crypto market, the tokenization market, the alternative financial access, the crypto investment community is a much different animal than the VC, private equity, hedge fund, investment banking community. It's a different beast entirely from a number of perspectives. So if you want to take that on and be part of that, it's a big thing, then do it. If you're not comfortable with it, I wouldn't advise getting into it.
And in any case, competent counsel.
Excellent. Well, I think we're out of time, so thank you very much, guys, for being here. Thanks.